Hi, I'm Emma Green, and this is Marketing Monologues podcast. And today we are joined by Ben, who a bit of a different guest because you're not a marketer.
Nope.
But you are a band member, a published author, and founder and solicitor of Ascender Law. So welcome, Ben.
Hi, Emma. Thanks for having me today.
It's okay. So you started off, graduated from University of Liverpool and LGMU, so two local universities. You've worked with Premier League clubs across the UK.
Yeah.
You've worked with restaurants like Mowgli, trainer brands. So how did you originally get into IP?
So my kind of history getting into IP. So as you mentioned, I was in bands, so I was very much on the creative side of life, and I'd done my law degree, and I didn't particularly like lawyers. I'll be honest. I kind of had done my kind of summer vacation schemes. I thought, well, what can I do that still means I get to work with creative people? And I was very fortunate at the time. I was introduced to Ben Hatton at Ripple Effect. And because I wanted to understand how creative people actually dealt with their IP. And obviously Ripple Effect, great marketers at the time, leading the web kind of side of life. And Ben Hatton said, well, you need to talk to my lawyer, Mark Shipley. And I was very fortunate then, because I went out for lunch and I talked to Mark and I said, look, you know, I'm not approaching this as a kind of traditional law student or a law graduate. I want to understand how creatives actually practically use their IP. Yeah. And Mark was great. Mark was very commercial. He kind of took me under my wing, and that's how I got into it. And it meant I could still work with creative people, web-based companies, marketers, fashion, food, anything like that, but use my training. So it was a great opportunity for me. And then from then on, 20 years ago, I've worked with some great people, David Worrell at Liverpool School of Tropical Medicine, Duncan Vaughan, who's head of legal at Iceland. And then I've gone full circle, and 20 years later, some of the guys I trained with, Mark Corrin, he works with us now. There's a team of 7 of us now, I'm going to say. Got a really strong team, great client base, really fortunate.
Fantastic. So when you think straight away like marketing, I kind of think of you would be very concerned with your brand name, your logos. So are those the type of things that marketers have to like really think about?
Yeah, I mean, marketing, it's such a broad term. So when we work with agencies, and marketing agencies, they do so many different things. So just this morning, you heard me on a phone call to an agency that does kind of experiential marketing. So big launches, big events where you have hundreds of guests, and it might be a new car brand or a clothing brand that's put this experience on, a Y2K experience, which is very buzzy at the minute.
Yeah.
Or it could be right down to someone that just does web lists, email lists and email marketing out, which is fine. It's just very different ends of the scale. So you asked then about whether it's all about trademarks and brands and whatnot. And a lot of what we do, it is about trademarks. So, every business that you probably deal with or know or touch on a daily basis, if you look at your phone, it's Apple or Google or whatever, it is very dependent and very protective of that brand because it attracts goodwill. It's very powerful. But there's so many different other faces and facets to marketing. So you've got your data, so data protection, so your email lists. How do you deal with that? And I know we've spoken before about AI and data and things to do or not do with that data. So that's really important. You have the experience side. So if you're a marketer and you're hiring venues or entertainers, there's that to deal with. Then you've got the trademarks and whatnot. And how do you protect that? So do you protect it from, registering it to prevent other people using it? But once you've done that, what do you do next? It's not just a
straightforward
one and done and that's it. It's then you actually need to enforce it. You need to monitor it and ensure it's used correctly.
Yeah. So when we say intellectual property, what exactly does fall under that? Because I know you've mentioned trademarks, but there's a whole range of assets and things.
Yeah, and I think we try and keep it simple. So we generally mean the 4 main IP rights when we talk about intellectual property. So copyright, trademarks, designs, and patents.
Yeah.
So that, again, we use the phone as a great example of IP. So if you look at your phone, I don't know if I've got mine around. So we look at my phone, we've got on the back of it, we have a trademark, which is Samsung. So that's your trademark. You've got the visual appearance, the shape, the design. So that's the registered design, they registered that. Within that, you have copyright. So you've got software code, which makes it work. So that's source code, and that's all protected by copyright.
Yeah.
And then you've got patents. Now, patents are not something I touch a lot of, and it's a bit of a dark art, but that's generally an inventive or technical step to solve a problem. And they're very strong, right? But you need more of a technical mind than mine.
So then when we talk about like trademarks, for example, there's Dyson that has the Cyclone technology. Yeah. There's Coca-Cola and they've trademarked their secret ingredients so you can't mimic or get the exact flavour of them. But then there's even like, you know me, I like Disney. So there's the Steamboat Willie animation that the trademark finished last year. So now you can kind of use parts of the animation, the script, the music without permission. So when we get trademarks, is there a deadline? Do we have to like renew?
So I think first off, the Coca-Cola example, it's an interesting one. You said that they've trademarked their secret ingredient. Now they haven't actually. So Coca-Cola, they took an interesting approach. So at the time in 1900s or whenever it was, they could have actually patented the medical formula. I think it was cocaine and various other ingredients, bizarre. But what they chose to do is rather than patent it, which would have meant it would have been disclosed to the world and anyone could have used it because it's on a public register. Yeah. After it expired, sorry. So the patent gives you the monopoly right whilst it's granted. And once it's expired, anyone can do what they want with it. So 20, 25 years or what it is around the world. Now, what they chose to do was to keep it secret. They kept it in a vault. It's a trade secret. So it's actually protected it for way longer than the protection a patent would have afforded it. Yeah. So Coca-Cola took a very commercial approach to their IP. They didn't patent it. They kept it as a trade secret and protected with confidentiality. So that's the Coca-Cola thing out of the way. On to Disney, which I know you love. Steamboat Willie. So this is an interesting one. It's just come out of copyright protection. So copyright and trademarks, two very distinct rights with different terms of protection. It's important that people remember that because often people think, oh, it's out of copyright protection. It's automatically available for me to use. It's in the public domain. So copyright, yes, is 70 years generally after author's life, etc. That's fine. Steamboat Willie is in the public domain now. You can use the copyrights. Yes. Now, what Disney do is they have a very rigorous trademark regime. So they maintain those trademarks forever. Yeah. So trademarks don't have a fixed term. So they're registered, and I think our oldest trademark in the UK is the Bass Spear triangle logo. I don't want to say what year it was registered, but it's very old, over 100 years old. And every 10 years you can renew it. As long as you're using it, you keep renewing it, keep renewing it, keep renewing it. Oh, okay. So actually what Disney have done is they have they know they've lost the copyright protection of Steamboat Willie, but they have quite a rigorous trademark portfolio. So if you were to start using Steamboat Willie on your lovely sign here or as part of the novel branding or whatever, you're going to get a knock on the door from Disney. So you've got to be very careful because that's use of the character in the course of trade. Yes. So though you might not be liable for a copyright claim, you could have a trademark claim. Yeah. So in the US, actually, I read this the other day, there's a US law firm who has put an advert together using the Steamboat Willie assets to advertise their law firm. I think it's done as a bit of a PR thing. It's like, look, we're going to get in the press to show we're taking on Disney. Yeah. So they wrote to Disney to say, obviously, it's in the public domain now. Can we launch this advert? Disney didn't respond. So what they've done is go to the American courts and ask for a declaration of non-infringement to say the advert's not infringing. Yeah. I think arguably there's some issues there about trademarks because they're essentially using the Steamboat Willie character in the course of trade to advertise their services. Yeah. But they've had the PR from it. So it's... Yeah. You know.
They've got that disclosure and they are safe, as it were. So yeah, because I mean, within branding in particular, there's obviously the fonts, logos and things like that, but there are products and, like, say, the Coca-Cola ingredients and things like that, website domains and addresses and all the data. But then, like you mentioned, there's all the infringements and possible infringements. And if you don't follow Ben on LinkedIn, get following him because some of your posts are brilliant. They're really interesting.
I'm glad you find them. Don't fall asleep reading them. Yeah.
No, they're really interesting. But I really liked your post about the Labubu toy that has just like blown up and every kid wants one. But then there's like the Lafufus, which have become almost arguably as popular because then there's the whole video of the unboxing to see how bad a fake they've got. But people are willingly buying them knowing that they're fake. Yeah. But how does like Pop Mart stop that, or can they stop that? And also it's the artist, it's his work ultimately.
So I think, Labubu is a great example. And, I've got personal experience because my 9-year-old was so desperate for one of these little monster dolls. So she went on eBay and found one, and we said, look, it's probably not going to be real. It's £9, and I don't know how much they cost if you go to Pop Mart.
Yeah.
We still got it turned up, and it's falling apart, and it's got the wrong number of teeth and all this type of thing. Apparently these things give it away that it's a fake.
Yes.
But anyway, it kind of led to a great opportunity to talk to my daughter about IP and the various IP rights within that doll. So there's the trademark for the name, there's the copyright and design protection for the shape, and various other features. Now, it's interesting, on the way here this morning, actually, on the radio, there was a talk about how much or how many products being stopped at customs, which is, pirated content or counterfeit product.
Yeah.
And Lafufus, as they're known, account for 90%, I believe, of the last month's custom seizures.
Oh my God.
So what you can do is, if you've got a trademark for a product or a registered design or something like that, you can notify customs, and what they'll do, they'll have a watch out for anything that's coming into the country, and they'll put a hold on the shipment, notify you as the rights owner, and then you've got an opportunity to either seize it or prove that you own it, and likewise the shipper can try and establish they've got genuine bona fide rights. But 90% of all product coming to the country that's been stopped is these Labubu dolls. It's a huge business.
Yeah, that is a huge number.
So what I'd say, I mean, we do similar for other brands that we work for, from tyres through to fashion, is to make these recordals with customs, which essentially puts it on a watch list and says, if you see this, seize it. It's because we own it.
Yeah.
And that's something you can do. You're never going to completely beat it. It's such a big business. But you can do what you can. Do your best.
Yeah. So another key example of kind of like an infringement and then ultimately a lawsuit, which made so many headlines last year or year before, was the Colin versus Cuthbert Caterpillar, which turned into like a huge social media frenzy.
Yeah.
But kind of like there's so many different supermarkets out there other than Aldi that have these caterpillars, but M&S only went for Aldi. So is it literally you can kind of get away with maybe a little bit of creativity or similarity, or is it just Aldi went too far and there was just too many things that M&S couldn't ignore?
Yeah, I think that some cynics think that M&S and Aldi were in cahoots and it was all a bit of a PR and marketing. And that something was settled behind the scenes because everyone did very well out of it.
Yes.
But I think Aldi have been prodding the bear for some time. I mean, their marketing and social team, as much as I love them, I mean, I'd hate to be their legal department.
Yeah.
It must be really difficult to make those calls. As I said, I think they were prodding the bear for some time. They've been pushing these lookalike products for a while. And there was a big case last year, which was the Thatcher's and Taurus cloudy lemon cider.
Yeah.
And that was a real flag in the sand that started to say, you've got to be careful about lookalike product. So the Taurus can was a cloudy lemon cider. It had lemons on it. It looked very much like the Thatcher's cloudy lemon cider. And generally, Aldi's got away with this for many, many years.
Yeah.
And actually, the court's decided in favour of Thatcher's this time. Some lawyers disagree with the finding. Others have seen it as a great opportunity to say, look, lookalikes are off the table now.
Yeah.
And I think it has. I think it's going to probably trigger a sea change at Aldi and Lidl, where lookalikey products are not... They're under a bit more scrutiny. They're not going to be so freely available in the middle aisle anymore. They're going to be more careful.
Because you walk down the aisle and they've obviously done it so as a customer, they can't say, these crisps taste like Walker's, but there's branding and the packaging is so similar that you're like, straight away you know what it's going to be because they've told you without telling you directly.
It's really interesting though, because I think traditionally the view was that although it looks the same, we know as consumers it's not. So there's no actual confusion or whatnot. It is taking advantage of that trade dress and how it looks though. And that's why it's, I think, swinging back the other way now. But the kind of traditional, we call it passing off. You know, if you look at a product and you think, oh, that's from M&S, but it's not, it's from Aldi. Well, that's where it's real traditional passing off. There's confusion and it's very detrimental to M&S. But Aldi have always been quite clear, well, our products, everyone knows they're ours. So there's no confusion per se. Yeah, they might look a bit similar. Well, so what? Consumers aren't confused.
Yes. Yeah. So it does the job that they need it to do type thing. And then say if you're a marketer and you're working in branding and you're either doing a rework of a brand or creating a brand, can you take like inspiration from other brands and like, again, how close can you get, or is it just let's just be safe and just do something completely different or new, to just try and stay as best you can?
Yeah, look, we're all inspired by things.
Yeah.
It's the saying is, standing on the shoulder of giants we see further than before, because we look at our experiences, our lived experiences, products that we've used, that we enjoy, and that's how we develop and build.
Yeah.
And we get better. So music is all kind of taken from a source, and we listen, we learn, and we do better, we do more. So I guess product development is similar. Now, if inspiration is, oh, I like that image and that font and I'm going to use it in my product, well, and it's going to look the same, that's more than inspiration, that's copying. So there's a fine line. It's very difficult to say where that lies. It's very fact dependent, but copying and inspiration are two different things.
Yeah.
So I think I wouldn't like to say inspiration is wrong or inspiration is right. I think inspiration is important. We all have those experiences, but just be very, very careful as to where the line is drawn. So if you're developing a product or a marketing campaign, I'd always suggest keeping hold of all drafts that you have to show iterations of where it came from, because that's part of copying. Is if you can defend yourself, if someone alleges you of copying because it's an independent creation, great. You can show this version was developed on this date and it started like this and it developed like this, developed like this, developed like this.
Yeah.
That's going to go a long way to kind of rebutting any issues you have. But if you've gone from 0 to 100 and you've got this end product that looks just like, I don't know, the product, there's some questions to be asked there.
Yeah, because that's a good point, actually, because branding is a process. And like I said, there's always a million iterations, whether it be the change of colours, fonts, but there's always a reason for it as well. So
yeah, mood boards. Everyone, mood boards are going to include certain things because that's the vibe you want. If you're making a font, because I love fonts, it's one of my kind of weird niches and hobbies. Swiss grotesques are always going to look very geometric, very clinical and very clean. You can't get away from that, and you're going to look at the greatest ones that have come before.
Yeah.
It's just the natural development of things.
Yeah. So would you say that kind of innovation is hindered slightly by IP, or obviously I'm presuming you're on the idea that it's there to protect innovation? It
is. I am, I'd say, probably more on the liberal side of intellectual property and protection, whereas I'm very pro open source, Creative Commons. I think there's a lot to be said for especially software development and how people can fast track development from here to here by use of open source. So I'm a big proponent of that. And some lawyers be like, oh no, but that's not what we do. We protect, and we're very much, oh, that's mine. But that doesn't benefit anyone. I think IP is great. In terms of rewarding and protecting effort. So patents is an example. So although I don't do a lot of patent work, medicines are protected by patents.
Yes.
Now, there's a reason for that. Medicines cost a lot to develop. They cost years of development, research and all that. Why would any entity put that time and cost in unless they know they have a potential commercial benefit at the end of it?
Yeah.
Those number of years where it's protected to go and sell it. And yes, it's unethical at times, especially in America and whatnot, but there has to be an incentive to create.
Yeah.
Otherwise, why would a big business do it?
Yeah.
So I don't think it hinders. I think there's a balance to be had.
Yes.
Is the balance right at the minute? I don't know. And there's all talks about, the UK and incentivizing, drug development and whatnot. But that's more of a policy issue than law.
Yes.
I think, the patents, patents are granted for a reason. Designs are granted for a reason. Trademarks are granted for a reason. But trademarks actually were originally granted to protect consumers. So consumers knew the product they were buying was from a specific undertaking. So that's not to protect big business, that's to protect consumers.
Yes.
I think, again, it has probably shifted slightly to be a tool of big business.
Yeah.
But that's why it was originally there.
Do you think as well your kind of opinion or the way that you kind of lean is also maybe a little bit down, like I know you said you're a creative yourself, so it's kind of you can see it from a creator's perspective as well as like an organisation and something that needs to be protected as a corporate organisation?
Yeah, I guess so. I mean, I've been in bands in the past where there's been fights over money, and probably there was slight naivety when I was young about how rights were dealt with, because music is notoriously confusing in terms of publishing rights, masters rights, and all that, and who's entitled to what.
Just have to look at Taylor Swift.
Oh, the whole system is so archaic. If you pick up a music contract, it's written in yeah, it's such hard language to understand. It's almost like old English without punctuation sometimes.
Yeah.
So it is difficult.
So the next question, this next part is quite a big loaded topic at the moment. So it's AI. Sorry. But it's such an interesting topic, probably because there are so many theories or question marks really over it all. So obviously with creativity, like we've just talked, with innovation, and if it is kind of hindered by IP and trademarks. But then there's also the age of AI where you can go onto many different platforms and create content and but you can do your whole brand within using an AI tool. So how kind of can marketers trust AI when we're developing content or copy or even like graphics and design?
I think the short answer is you can't. I mean, before the age of AI, I had a full head of hair and no grey in my beard. But look at me now. I mean, I get phone calls from our agencies all the time saying, can we use this AI tool? Or the contract from the client says this. Can we do this?
Yeah.
And it's very difficult because the legal position about, AI generated works is not clear in the UK. The government has issued a paper about this. It said the law is outdated. It needs updating. But until the fast paced development has kind of slowed down and we know what the lay of the land is going to be, we're going to hold steady and just keep it as it is with this slight grey area. Yeah. So from a marketer's perspective, it's really difficult. I think the first port of call has to be look at your contracts with your customers if you're a marketing agency. Because a lot of the big brands, and I've seen this the last couple of weeks, are including provisions in their contracts that say you can't use any Gen AI unless we agree to it. Then I saw one the other day that says you can use Gen AI, but you need to warrant that if you use it to create any image or copy, we own it. I was explaining to the agency that we can't give that warranty. So warranty is a promise. And if you give it in a contract and it's wrong, you're in trouble. It's a contract breach. Yeah. Because technically, the position in the UK at the minute is if you use Gen AI to create a work, no one really knows who the author of that work is yet. Is it the person that's prompting it? Is it the software tool? And the CDPA, which is the Copyright Act, it's kind of a bit opaque. We have some old legislation in there from 1987 that was designed to deal with computer-generated works that says essentially the person who made the arrangements for the creation of the works owns them. Yeah. But we don't know if that's the prompter or if it's the person that created the LLM or the tool or whatever. Yeah. So you've got this issue. So if you'd sign that contract saying you warrant we own those works if you use Gen AI, well, you can't. So I always say to clients, how can you make that promise? You're in breach. Yeah. So I say marketers, look at your contracts first, and then also look at the terms of use of the tool. So if you're using a tool to create a new campaign for, I don't know, let's use Samsung as an example again, because we were looking at that. And Samsung have given you their roadmap for the next 2 years about product launches. Yeah. And you upload that product plan to whatever tool you're using. That plan is ingressed into that LLM. It's going to be used to train on and potentially regurgitated for someone else that's asked for show me a product roadmap for 2 years for development for phones or computers or TVs. Yeah. Samsung aren't going to be happy. You're in breach of your terms of confidentiality with them. Yeah. And it's going to cause you a whole headache. So I think we're actually on a ticking time bomb of use of Gen AI because no one knows the answer. Clients are getting wise to it. And we don't know which way it's going to go.
Do you think as well with the, like you said, the grey areas, that it's then also maybe difficult for people to claim where the trademark has maybe been leaked? Because that could have come from, how do you chase it basically?
It's difficult. So that's kind of liability for outputs. And again, that's something that's not really certain at the minute. But with trademarks or even copyright, if you're distributing materials that contain the infringing content, you will be very likely on the hook. Yeah. So if you've used Gen AI and said, oh, make me a new computer brand, and it's spat out a load of material saying, I've got a great brand, it's new, it's called Apple. And you then start branding stuff up as Apple and distributing materials, you're in hot water. And you can't just say, oh, well, ChatGPT told me it was okay. You've got to be a bit more careful and diligent. So it's, from a marketer's perspective, it's be sure of the provenance of your outputs. So, do you own them? What are the terms and what are the terms of the tools? But also the kind of terms with your clients.
Yeah. And then how do you kind of think, obviously you stay compliant. I think what you were saying earlier about just keeping that constant audit and traceable workflows and things to show how you've used it. So I think that's a good way as well, just to show the creativity side, and that where the ideas and concepts have maybe come from to how you've created it, because that's the problem is there's a big worry that creativity is just going to fizzle, where AI is just going to come in and do all the creative work for you. You stick your name on it and go, ta-da.
Yeah,
done.
And I've said to you this before, and said to you about this before, and there's a massive issue about AI slop, it's called, isn't it? That's out there, and it's all slightly looks the same, and it's got the same feel, and it's boring.
Yeah.
And I think that is an issue.
So another thing with AI is that you can use kind of the tools to create, as I said, a whole brand. You could create logos, and then you could ultimately just come along and stick your name on it and present that as the final package. So kind of, do you think it's ruining creativity, or how do we own that creativity? Is it through, like I said, the process of an audit trail, and here's the streamlined workflows that we've kind of A to B, or how do we get to that?
Yeah, I think first of all, we need to acknowledge, especially in marketing agencies or creative agencies, that Gen AI is here. It's going to be used.
Yeah.
Rather than saying we can't use it, as some brands are, we accept that it's going to get used, and it probably already is by some staff members.
Yes.
So I think the first port of call is to actually sit around and talk to your team about how is it being used, and why do you use it? So the whys, and are we shortcutting? Are we using it to spit out all that creative, as you said?
Yeah.
And then put together an AI policy, which says we use it for this cause or this point of the work, or is it sense checking? Is it just casting an eye over stuff?
Yeah.
So it's setting out what tools we use and why. And then we've got something that we can refer to that everyone's kind of singing, from the same hymn sheet, to start with. We can then look at actually using the tools or engaging the tools, paying for LLMs, which then might put some privacy guardrails around the data you're uploading. So that's advisable. So if you're putting the briefs in there, it's not going out there. Then you asked about kind of killing of creativity. And I'm worried about that. You listen to the AI generated music, for example.
Yeah.
You think, bloody hell, like some of this is charting in Spotify.
Yeah, it's like, crazy.
It's like, this is mad. I saw an AI artist got a £3 million record deal today. It's not even a real person.
Yeah.
And you think, wow, as a musician, would I want to be going into music now? Yeah. I do think there's a concern. And I think this is probably tied more to how I see policy needs to develop. So we still need to have a system of rewarding creatives so that people are inspired to still create.
Yeah.
Otherwise, why would you? It's already an issue. The creative industries are dying because there's no support for it.
Yeah.
I think the UK, creative industries and music and knowledge is our biggest export, but we're not championing it. We're not supporting it enough. Now, if there was those incentives, people would still create. People would still write music, books, poetry, articles, whatever, because they're going to get paid for it. But how do we do it? And I kind of think we need to look to the past. So we need to look to the past about how we've dealt with technological innovation over the years. So look at when the ability to copy music came in, so CDs and vinyl and whatnot.
Yeah.
So we introduced the Mechanical Rights Society that said if you want to press a CD, you have to pay a license fee to do it. Or sorry, press a record, you have to pay a license fee to do it.
Yeah.
So why can't we have it that if someone is asking an LLM to reproduce a piece of artwork that looks like, I don't know, think of a modern artist. Can you think of any modern artists? Gone blank.
I said Taylor Swift earlier, so
Taylor
we'll
Swift.
Swift.
Make me a song that sounds a bit like Taylor Swift. Could we have it so that then triggers a small royalty payment to Taylor Swift? And then there's a clear, but also with the outputs, there's a clear transparency that this is something AI generated.
Yeah.
I think that way the artist is still rewarded because there's a trigger somewhere in the back end. And look, there's got to be a way of doing it. We've got these fantastic tools to develop all these things now.
Yeah.
But also allows the AI generated works to be created, which, they're not going anywhere. It's going to continue.
Yeah.
Again, that's for people cleverer than me to think about and how we kind of implement that change.
Yeah. I think it's also interesting, like you said, where there's people kind of like big names as well who are just like claiming, oh, we've not used this for AI or I think it was in the summer, there was this girl on Instagram who she's got like thousands and thousands of followers, and she's at all these world events. She's wearing all the latest like designer clothes. She's like with celebrities or with other people. And then she posted a photo in summer where she's at Wimbledon.
Yeah, I saw that.
Yeah, and she's not obviously not at Wimbledon. She's twice the size of the small, tiny man next to her. But she has thousands of followers, and ultimately she's selling a lifestyle and potentially selling products or something else to customers, but that's obviously a massive breach of trust, because you kind of would buy something from her thinking, I'm buying from her. You know, it's obviously a sponsorship or some type of brand deal that she would have should she be real, but because she's then completely artificial, it's like that trust level completely goes. And then it's a bit like with influencers where they've had to put in the past on posts, this is a paid ad, I'm paid to talk about this product. So is there going to be, do you think, more legislation where it's going to be, if you use AI, you really are going to have to state on adverts or posters or any type of creativity or creative work that AI has been used?
Yeah, I think so. I think the ASA, which is the Advertising Standards Agency, will make a massive step in this area. And I think it's important. You mentioned trust, and I think that's, you know, goes hand in hand with transparency.
Yeah.
So I use AI generated images for my LinkedIn post, for example, you mentioned earlier, because it's easy, you know, it's something that can, you know, on a theme you can chuck out there, it's great. But I always have the little badge that says it's AI generated in the corner.
Yes.
I think that's really important, because trust of you, your product, your marketing is important.
Yeah.
But also, if you're using AI to create marketing, you need to check, for instance, product claims that are in that marketing. You know, you need to make sure there's nothing claimed that's not true, because AI will just spit out what sounds good, right?
Yeah.
So if you've got an influencer or a product mock-up or some packaging or marketing that says, I don't know, let's say this product is eco-friendly. It's the most eco-friendly dishwasher and the planet, I don't know, something like that, and it's not true, you've got an issue with the ASA. So you need to, I think, disclose if you're using AI, but you also need to sense check everything you're doing to make sure that people can trust what you're doing.
Yeah. So how do you, if you're like a small business, what would kind of like the tips that you would say for somebody who's like either setting up, or what resources are out there if people just want to cross check or double check that, one, they're not infringing anybody, which sometimes you'd find out the hard way, but also how they would maybe protect their owner, just make sure they're being compliant at all times?
So copyright is very difficult because there's no central register of copyright. It's just a right that arises automatically on the creation of an intellectual work by an author. Yeah. So it's not easy to do a check. You can do like a reverse image check on Google, maybe. That could be something you can do. Okay. But it's difficult. Yeah. Now, with trademarks, it's a bit different because trademarks are a registered right, for example. So if you asked ChatGPT to create you a brand and it came out with Apple, you could then go to the UK IPO's website and you can use the search for a trademark function, and you could type in search for Apple or marks similar to Apple in class 9, which is the class for computers. Yeah. And it will show you, hang on, there's a brand out there called Apple, you're in trouble. Yeah. And I think trademarks are really important to be aware of when you're marketing a product, because there doesn't have to be an act of copying. It's a monopoly right. It just has to be similar, materially similar, in respect of similar goods and services to something that is registered. Yeah. So you've got no defense if you launched a computer brand called Apple, even though you hadn't copied it. Yeah. You know, you're not an innocent infringer. You're in trouble. Yeah. So I'd go to the UK IPO, I'd click the search for trademark link and do a bit of brand clearance that way. You could do more in-depth searches, and we do those day in, day out. They cost money. So obviously the first check should always be just use the UK IPO. Yeah, because I was going to say, even when you go on like Google Images, you can filter them, and they have like copyright straight away. You can filter, or commercial use, and what you can and cannot use is made quite apparent quite quickly. You have to be careful with that, though. I mean, my wife was writing a paper for publishing the other day, and she said, "Look, can I use this image? Can I use this image?" And she was going through the Google license-free image, or I think they call it public domain or something, which is a slightly opaque term. Yeah. And of course, if you link through, you end up on iStock's website or whatever, and it's not clear what the license terms are. Do you get a license if you're not subscribed? Do you have to subscribe? So you've got to be really careful, even when just using Google Images that claims to be copyright-free images. Yeah. Check the terms. A lot of them are Creative Commons, which have a right for the author to be identified. So always make sure that you're aware of the license terms that apply. Perfect. And then what kind of like tips would you give to a marketer just generally with the trends going forward, just the due diligence constantly? Yeah, it's something we've spoken about before is data. So obviously everyone has email lists for their marketing. We've got clients that have got loads of email lists, and they suddenly say, well, we want to use it for this purpose. We want to chuck it through this and create this, whatever experience.
Yeah.
Now the point with data is we've got a very robust legislation. We've got the GDPR, which is a headache for many. We've got the kind of PCR, which is the privacy and e-communications regs, which deal with how you use email and SMSs. Yeah, any digital marketing essentially.
Yes.
And what you can and can't do. So the general gist is you can only do with that data what you agreed with that user when they gave it to you.
Yeah.
So you can't suddenly say, oh, now we want to chuck it through AI to create X, Y, and Z unless the user agreed to that at the start.
Initially, yes.
So you've got to be very careful. So I'd start saying, look at the data you've got that you want to use, audit it. That's for one thing. And then I'd say also audit your contracts. So contracts with customers, contracts with your tools about ownership. Are you allowed to use Gen AI, not use Gen AI, confidentiality, all those types of things. It's a bit of a housekeeping exercise, a bit of a pain. But as I said, I think it's a bit of a ticking time bomb that if we don't deal with now as marketers, it could bite you in a couple of years' time, because there's going to be an influx of kind of lawsuits and cases, whatever, about, well, that's copied from that. Who created that? And you did that. You breached my confidentiality. What do you do with that data?
Yeah. So if it's all thrown into AI for then being able to use for remodeling or creating something out of it, then, like you say, you ultimately have put that into the domain some way. Yeah. So to end, do you have like a favorite campaign or example or something that you kind of just saw and really liked?
Yeah, so I do a lot of brand licensing. So that's where a brand is well known and they give someone else the right to use that brand, and it kind of comes together and creates a whole that's bigger than the single.
Yes.
So for me, Marmite has absolutely smashed this space. And I think I posted about this before, which we spoke about, which is if you go into M&S, there's endless products which are Marmite themed or Marmite licensed essentially. So you get a pizza, which is made by M&S, but obviously Unilever have licensed the Marmite brand and the ingredient to them, and it's created this whole range now, which for Marmite lovers like me is fantastic.
You're a lover, not a hater.
Yeah, I love it. So I think, the use of clever licensing and collaboration can actually take your brand into different sectors, that are maybe outside your core range, and create more brand awareness, because I posted about it. It's free advertising, right? And also different channels of sales that you wouldn't have got before. Yeah,
that's brilliant. So thank you very much, Ben. Thank you for joining us.
Thank you, Anna. Thank you.
Thanks everyone for watching, and we'll be available on Spotify, YouTube and Apple Podcasts, and make sure to tune in next time.